Good afternoon. Welcome to Long Live Third Parties Podcast. Free Press Media Press, Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bichard. Today I read the case, Matter of Glickman v. Laffin, 142 AD 3D 730, New York, Appellate Division, 3rd Department, 2016. Friends, today we're going to talk about residency requirements. So get your residency requirements thinking hat on. We are going to discuss that. This case involves our friends at the Working Families Party. As we can see from these cases, we've discussed a number of Working Family Party cases on this podcast. The Working Families Party is very active. They're very active on social media, I see that too, as I follow them on social media. So what happened in this case, friends? Let's read from the record. It says, quote, Stephen Glickman filed designating petitions with respondent New York State Board of Elections, naming him as the Democratic Party and Working Families Party candidate for the public office of the state senator for the 55th Senate District in September 13, 2016 primary election. Zachary Laffin, Silvio Palermo, and John D. Moffitt Jr., herein collectively referred to as objectors, filed written objections with the state board challenging, as is relevant here, the validity of the designating petitions, claiming that Glickman failed to meet the mandated residency requirement of the New York Constitution in that he had not resided continuously in New York for 5 consecutive years, nor in the Senate District for 1 year immediately preceding the election. Glickman commenced proceeding number 1 and proceeding number 2, seeking an order validating his designated petitions for office at issue for the Democratic Party and Working Families Party, respectively. Thereafter, objectors commenced proceeding number 3, seeking to invalidate the subject designated petitions and enjoining the state board from placing Glickman's name on the ballot for the September 13, 2016 primary election. Following a hearing on all 3 petitions, Supreme Court, among other things, granted objectors' application to validate the designated petitions, finding that although Glickman met the 1-year residency requirement, the fact that Glickman registered to vote in Washington, D.C. in 2014 precluded him, as a matter of law, from establishing the requisite 5-year continuous residency in New York. Glickman appeals and objectors cross-appeal. End quote. So friends, think about this. Do you think 5 years continuously residence in New York is a good requirement for running for office? Do you think that's too strict? Do you think it's okay? We don't care about the Democratic Party part of this on this trial because we are against the Democratic Party, at least the way things are today. We do care about the Working Families Party, and since the Democratic Party and the Working Families Party are combined, the Democratic Party is going to get a free ride for us today. We want to advance the Working Families Party as much as possible. In many cases like this, the courts are very strict and they will deny third parties access to the ballot for these reasons. So how do you think this court decided? Let's find out what they discussed. Part of this trial, this case, involves discussing the notion of residency. What does it mean to be a resident? I had this issue when I was registered to vote a long, long time ago. I was in Wisconsin for a short time. After I graduated from graduate school, I was in Wisconsin. But before then, I was in Minnesota. And it was at the time where the elections of 2004 were happening. So I wondered what to do. Since I was in Wisconsin at that time, I registered in the primaries and I voted in the primaries. When I moved there right before the election, the general election, I moved to Minnesota again. A different place in Minnesota, but Minnesota nonetheless. So then I had just enough time to register to vote in Minnesota, and I voted there. So those types of issues can arise not only for people who are voting, but for candidates, as what happened with Glickman. It says, quote, "It is well recognized that an individual can maintain more than one residence, but can choose only one for election purposes," end quote. They also say, quote, "We disagree with the interpretation by the Supreme Court and the dissent that Glickman's act of registering to vote in Washington, D.C. in the November 4th, 2014 election precludes Glickman as a matter of law from selecting New York as his residence for candidacy purposes. We do not believe that such act by itself amounts to candidate's manifestation of an intent to remain for a time in the locality where such registration took place." So friends, do you think that reasoning is good? It backs our third party side, so we tend to like such things. They talk about his circumstance here. It says he did alternate between New York and Washington, D.C. His father lived in New York, it says, and he stored some belongings, and he also kept his health care providers in New York. And he also, it says, he belonged to a synagogue in New York. And not just an inactive member, but an active member. And it also states he did some stuff in Washington, D.C. So there's ambiguity here. Where does he reside? So it is one of those tough calls. They also mention other things that come into play. They state, quote, "Because objectors failed to establish by clear and convincing evidence any aura of sham in Glickman's electoral residency for the purpose of retaining candidacy, the petition should not have been invalidated," end quote. It sounds like Glickman here is not doing anything fraudulent, like the phrase aura of sham would suggest. It sounds like it's somebody who is in the middle. He has a base in New York, yet he's done activities in Washington, D.C. A lot of people are in similar circumstances. Of course, there are people who fudge and exaggerate residency to serve their electoral purposes. But fortunately, the courts are not accusing Glickman of doing this. As we discussed before, he had a lot of legitimate reasons to claim New York for his residency. And it also states, quote, "As objectors failed to establish by clear and convincing evidence that Glickman did not meet the constitutional residency requirements for candidacy for the office for which he was nominated, Glickman's designated petition should not have been invalidated," end quote. So take that, objectors. Take that. Glickman fought and he won. We like to see that. We love to see third-party victories. Long live third parties. Goodbye.